Senator Hirono.
Thank you, Mr. Chairman. Well, it's pretty clear that the current situation is untenable vis-a-vis Congress's ability to get information from the executive branch. And when we start talking about the executive branch, the judiciary as being co-equal branches of government with Congress, when it comes to Congress's ability to exercise its own responsibilities and prerogatives to obtain information, the executive branch, as far as I'm concerned, aided and abetted by the OLC, has other ideas. So separation of powers doesn't work in a situation like this. So listening to all of you, I think we agree that the current situation it doesn't work because the so-called accommodation process is not even working when you have an executive branch that basically says, you know, go fly a kite. And I do think that going to the judiciary is one of the ways that we can approach this, as long as there's not just a whole lot of delay going on. For example, the Don McGahn situation where he waited out the clock for some 2 years, that is not going to help this circumstance. So if I am still of the opinion that a judicial approach can work if we lay out the parameters and time frames for that. And I also like the idea of Congress having its own OLC and our own ability to have this neutral entity, neutral in the sense that it's a counter to OLC. I like that idea that at least we have somebody on our speaking for the ability of Congress to get this kind of information. So we shall proceed under the leadership of our chairman. And I know that you have provided some suggestions. I would say a compilation of these various suggestions would probably be the way to go. And I look for your leadership for us to come up with a bill that would get us off the dime. Thank you.
And I would only observe that the perfect can be the enemy of the good. But to quote Senator Hirono, the position we're in right now is simply untenable. I mean, we're in a worst case scenario right now in which congressional oversight, which is very often described by very learned experts as a function of Congress as important and as significant as its legislative function, that one of the twin key functions of Congress has now been essentially completely disabled. And so while there may be some hazards and difficulties with some of the proposals, I guess I'll ask Mr. Townsend and Dean Rozelle, we're in about as, do you agree that we're in about as bad of a worst case situation as the country's ever experienced with regards to these disputes with the breakdown of the accommodation process?
Well, Mr. Chairman, I would say that...
Your mic, I'm not sure is...
Is it on now? I'm sorry, I'm having trouble with the button. I would say that we are in a very bad place, a somewhat better place in the aftermath of the Mazars decision, which laid to rest some of the misconceptions about whether the federal courts have jurisdiction to adjudicate civil actions that are taken to enforce congressional subpoenas. So we're in a better place because of that. But we have a lot of work to do. I say we, the Congress has a lot of work to do to strengthen its position. The condition of the accommodations process is really a byproduct of a history where Congress has sort of had one hand tied behind its back without having an Office of Legal Counsel or some sort of mechanism to bring Congress together to state its legal opinions and provide a counterweight to the Justice Department OLC. We're in a position, Congress has been in a position where it has had provisions in law that have restricted the Senate's ability to bring civil lawsuits to enforce subpoenas that are brought to executive branch officials. That needs to go. There are no, there's nothing in the law that says what the penalties are. There's nothing in the law that makes it clear that the courts, that these actions have to be considered. So there's a lot that can be done. I think we should talk about the idea of mediation. I want to save time for my colleague, but I think there are a lot of things that should be done ahead of looking to mediation.
I agree.
I'm not at all interested. First of all, I'm not all that interested in penalties, just to be clear for the record of the hearing. I think resolutions and rapid resolutions so that we can get on with the business of governing are the key, and penalties should be reserved only for the most extreme contumacious type conduct, and that is not part of what Senator Kennedy and I are pursuing. It's a process that leads to a reasonably quick and reliable outcome, and that the prospect of which influences the behavior of the parties such that the more extreme and exotic positions that are taken fall by the wayside, and we get more quickly to the amicable resolution that is the, I think, ideal outcome, and the one that the court has indicated Supreme Court has indicated it would prefer. Dean Rozelle, I interrupted you.
No, that's fine. Senator, thank you. And I agree we're in as difficult a situation, I think, as ever with regard to issues of executive privilege in the accommodation process. I began my research on executive privilege back in the 1980s. My first book was in the early 90s. I testified in the early 2000s several times. I've observed a lot of these disputes going back and forth. And just as an example, during the Reagan years, there were multiple cases where the president claimed or threatened to claim executive privilege. Congress used its tools. There was a back and forth, and ultimately there was a compromise. And both sides walked away claiming victory, and they were able to move on. And so in my earlier research, I pointed out so many examples of where the process of give and take, negotiation, and compromise resulted in outcomes that were ultimately beneficial to the public interest. It wasn't a perfect process, and there were problematic situations and cases where it was not resolved perfectly. But I think we're in a very different situation now. Congress employs the tools that it has very vigorously to try to get access to information, and the executive is simply just saying, we are not willing to cooperate at all, take us to court, and just keep using all your tools, but you can't have it. It's been something of an evolution in my own thinking about this, because for years I had argued that the natural give and take back and forth in the system of separation of powers was the ultimate process for resolving these disputes, and that we didn't need a legislative definition of executive privilege or to routinely involve the courts in trying to resolve these disputes. But again, I think we're in a very different place now, and I agree that some reform, some action needs to happen.
Well, I'd propose to you that this is less about you changing your opinion than the terrain
Yes.
Over which your opinion plays having changed. But Senator Blumenthal is just arriving. Let me ask Senator Hirono to ask her questions, then we'll turn to Senator Blumenthal. Give him a chance to get himself seated and organized.
Yes, thank you, Mr. Chairman. Dr. Rozelle, I agree with what I've heard here today, that mediation or expedited civil litigation is probably the way to go. But in light of the executive branch's refusal to enforce the criminal contempt statute against itself, I wonder about the need for something like an independent counsel as a last resort. Do you have any reaction to that idea?
That is one potential solution for sure, but the committee's also offering the idea of a kind of judicial entity, right, a mediator to take this role, and I agree that just coming up with a new office and thinking that you could magically find the neutral people who would populate that office and be able to mediate these disputes is extremely problematic. Look, I think every Congress should push the White House for its version of the Reagan memo. That was a good memo. It articulated the circumstances under which executive privilege would be asserted, the various conditions under which information would be turned over, and it said that the presumption was in favor of openness and that ultimately there should be an accommodation and compromise. So
We did have an independent counsel from 1978 to 1999.
Yeah.
And some of this, the accommodation process as being gradually changing, but I'm glad you mentioned the Reagan Office of Legal Counsel issued a series of opinions directing the U.S. attorneys not to enforce the 1930s criminal contempt of Congress statute against executive branch officials acting at the president's direction. So can you, this is for Mr. Stiff, sorry. Can you describe the criminal contempt statute briefly and what is required by its text and what OLC's 1984 opinion says about it? Because suddenly in this opinion, the U.S. attorney basically ignored the plain text of the criminal contempt statute.
Thank you for the question. So the way the criminal contempt of Congress statute essentially works is that there is a determination that an individual is in contempt of Congress because, having been served with the subpoena for documents or testimony, they, in the chamber's view, failed to comply with that subpoena. There is then a certification made to the appropriate U.S. attorney, so the local U.S. attorney. And the statute says that it shall be the duty of that U.S. attorney to present the matter to a grand jury for the consideration of an indictment.
Yes, shall.
Shall. So the opinion that you've referenced interprets that statute to retain prosecutorial discretion whether to pursue a particular prosecution, and also they do not construe it as applicable in instances where an incumbent president has directed the noncompliance on privilege grounds.
So I'd say questioning that OLC series of opinions is another way to go, because that's when shall is not deemed to be shall. Thank you.
Thanks, Mr. Chairman.